Okay, everybody, I think we're going to go ahead and get started. They are streaming this to Charleston, too. So hopefully they are seeing us. We understand they're on a 30-second delay in Charleston, and they're going to email us any questions they might have. And we're filming this, so I have to keep reminding myself not to walk in front of the camera over there by Matt. So you're going to see me take a little long route. That's why I'm doing that. I'm Tammy Besherse, and I'm at Appleseed. We're a nonprofit that works on a number of issues, including immigration. And I'm going to start out first and kind of talk to you about who unaccompanied alien minors / children are. Some say UAMs, some say UACs. And then we're going to turn over to Mike. We will have a short break after me before we get to Mike. And we can take questions during. So we'll go ahead and get started. And we're going to talk a little bit about who these children are, why they're coming, how they get here, and then what happens when they reach the United States. So under the law, they are basically children who, when they are under 18 and when they actually enter the United States, they don't have a parent or guardian with them who can take immediate care of them. And that's why they're called unaccompanied minors under the law. And that's just a federal definition. So they're coming over for a lot of different reasons. And what happens typically is they're mostly coming from Guatemala, El Salvador, and Honduras. And we do have children from Mexico, but mostly those three countries, which are called the Northern Triangle. And you'll see, looking at the map, that they're coming a long way from those countries, all the way up through Mexico and then into the United States. So it's not an easy journey. And we're going to talk a little bit about that journey and what these children go through. Usually they're coming because, in different countries, the laws are not as great about child abuse and child labor. And they may be already working at young ages, not getting paid, facing child abuse, maybe in a country that doesn't recognize it as child abuse, where all laws would, and they can't get needed help. And this is an example of a story that Nina Cano, who is an immigration lawyer, had. This is one of her clients. She had a 15-year-old client whose mom came to the United States, left her with family. That family took her out of school, forced her to do cleaning and labor, and she was basically beaten if she didn't obey. She was bleeding and bruised constantly. She tried to call mom to get help, but she could never get away to get some privacy to do that. And the beatings got worse. She finally ran away and decided to come to the United States and look for her mom because of the abuse she was enduring there and not able to get help. And this is one of Nina's actual clients. There's extreme poverty in most of these regions. This was another one of Nina's clients, Jorge. And he doesn't actually speak Spanish, but he speaks a dialect. He has many brothers and sisters. His dad was shot and killed when he was 12, and he basically had to drop out of school and become the man of the family and deal with all that. They have very little food, almost always hungry, and he basically decided that he and another young boy were going to go and find work in the United States and earn some money. So that's another reason that they flee. There's also family reunification, and a lot of people, they have a parent here, and they haven't sometimes seen the parent in years, and so they come back and want to get reunited with that parent, and you rekindle that relationship. Others are fleeing gangs, and the reason that a lot of people join the gangs is, quite honestly, the gangs have money. The gangs can provide food. Sometimes the gangs run the police. And a lot of times if you don't join the gang, they will kill you. So that's another reason that the youth flee. And they may not want to join the gang. This is the only option to leave. The police don't always protect. We find this is especially true with women, especially when it comes to how women are treated in certain countries and their lack of rights. And what happens if they call the police for assistance. With the gangs, a lot of times The police are getting money from the gangs, so they're not going to step up and get involved and help. So all these reasons, child abuse laws not in effect, the gangs, the recruitments by the gangs, the police not protecting from violence. There's also natural disasters that occur. Poverty and family unity are why the youth start coming over. Now, they get here in different ways. The main way is by foot, and you saw that map. We're talking coming down from the Northern Triangle all the way up through Mexico and in the United States. That is a long, hard journey. And they typically are brought through by what are called coyotes who are making money off them to lead the journey. Many children face abuse along the way coming up that path, especially females. It's not uncommon for females to be raped on that journey. People are robbed on the journey and face a lot of violence. If they don't come by foot, the other way they come is by train, and it's called the Beast or the Train of Death. And there's a reason for that. This train runs the length of Mexico. It is a fast-moving train. People are usually on top of the train because it does haul freight. At the various stops, people are robbed on the train. People can fall off the train. People fall off when they fall asleep. They get injured, they get cut, they get maimed. So this is a rough train to be on. The gangs also watch it and rob people and try to take what they have. So this also is an issue. And once the kids actually reach the USA, they usually turn themselves in to a border officer. And then they're processed, their age, their identity, fingerprints. They're served with charging documents, which Mike will speak a little bit about. They receive a little bit of medical treatment, not a lot. And they're asked questions about, are they abused, neglected, abandoned? Are they fearful of anything? Do they have a parent here where they can be transferred to custody to that parent? If sometimes if it takes a while for the parent to get here, they may be transferred to the Office of Refugee Resettlement. Sometimes they're actually held in detention. And that can last for several days, sometimes months. They do have what they call family detention centers too, but there are a lot of lawsuits over these detention centers and how they're set up, so they're not great places to be. Now, once they're transferred to the Office of Refugee Resettlement, if they have a parent or guardian here, they can be reunited with one of them. If not, then they have to go into foster care. And the youth are placed in deportation, also known as removal. Typically those in South Carolina go to court in Charlotte, and they have to face those charges and answer to the judge why it is they can remain in the United States, what their defenses are, and if they don't have any, they can't stay. The Office of Refugee Resettlement will work with the parent to talk to them about what they have to do. They do have people to speak various languages. They do have the packets in Spanish and English, and they go over things verbally. Office of Refugee Resettlement will close their case after 30 days. And the reason the kids from the Northern Triangle area aren't turned away at the border immediately is because of a federal case that's been pending for quite some time, and it's still a law about how those children have to be treated. Kids from Mexico and Canada also have to be screened to see if they have any credible fears to be going back, but they can be turned away more easily and versus going into the Office of Refugee Resettlement Care because they're not under that same federal court ruling. The parents are told about enrolling their kids in school, having to pick up their kid with an ID. They supposed to. Office of Refugee Resettlement was inundated for a while, wasn't following quite everything as they should, but now I believe they're back on track. They are told, your child does not have legal status. Your child must go to court. If you move, let immigration know. Lawyers aren't free, but they are given a list of pro bono or low-cost providers. They're told about a program which we'll talk about that talks about what happens in immigration court. about child labor laws, about what abuse and neglect is, about sex trafficking, and about here you should call the police for help. And then other voluntary services they might be eligible for. So the parents are told a lot of this information. They're told about the legal orientation program for custodians. And it tells parents, this is what will happen in immigration court. Here's what to expect. Expect delays in court. Expect to have to show defenses. And we have in the room, I know the Charleston people can't see them, but the attorneys from Legal Services of the Southern Piedmont who actually handled the removal case, and they're in various places spread out here. Maybe on the break, people might get a chance to catch up with them. And they handle the removal cases for free for these youth. They're funded through various grants to do that. And so they handle the immigration piece while we'll be asking you lawyers here that are South Carolina licensed to handle the family court piece. That's so key. And we talked a little bit about this, enrolling the kids in school. Social Security number is not required. I get asked that often. They're not. Everyone has to go to their court hearings. The court does have interpreters, so families don't need to worry about that. Also outside the courtroom, they do have a pro bono room a lot of times where families can stop and talk to the lawyers and ask if they qualify for anything, and that's a lot of times where Legal Services Southern Piedmont is. And they're told about the LOPC training, so there's some avenues to find out about their rights. And there's different defenses that the youth may have. We're only going to talk about one today because it's the only one that we're training on, and it's called Special Immigrant Juvenile Status. And Mike's going to go into great detail on this. And it's basically a two-part process. The first part requires a family court order. And we'll be dealing with youth who live in South Carolina, which means a South Carolina family court order. And then there's the immigration piece. You will not be handling the immigration piece, so don't worry about that. You don't have to go to Charlotte and do anything or send in the 360. But Mike may touch a little bit on it just so you understand how the immigration piece works and have a better understanding of what's required and why, and based on his experience, things that we really need to have tight in a family court order to not cause issues on the immigration end. So that's going to be the main thing that we talk about today. And now sometimes the kids may not meet any criteria or have any defenses. And if that happens, they will be ordered deported. Those who don't go to court will be ordered deported. Immigration doesn't take this lightly. They do go pick people up and remove them from the country. There are no free lawyers in immigration court. You must either hire one or see if a nonprofit can represent them. This is true even if the person is a child. So the way the immigration system is set up, even if the kid is 10 years old, if they don't have a lawyer for immigration court, they have to represent themselves. So that's why it's so important that we have, obviously, what Legal Services of Southern Piedmont is doing, but also the part that you'll be handling. The United States government did try to start a program to help the youth, try to prevent them from taking that long, dangerous journey we talked about. And it's an in-country processing program, but it doesn't work. And here's why. The kids have to be in that country, and they have to apply from that country, but the parent who's here in the U.S. has to have legal status to bring them over. Well, the parents typically don't have legal status that are from these regions. So this program's not working out real well. And so we're still seeing youth come to this country because they don't meet these rules. So even though the U.S. government did this, they just don't meet the rules. So they're going to keep coming over. Now, a little bit about how our pro bono program is going to work is the attorneys I referenced will actually screen the youth in Charlotte. Make sure they're low income, so that way we can ask for fees being waived for family court and things like that, because that's also their criteria. And they will make sure they qualify for special immigrant juvenile status. Now, the reason they're partnering with us is they don't have South Carolina licensed lawyers, so they can't go into family court and get the piece that they need to help with the defense. they'll contact me and say, we have a youth who qualifies. Do you have a pro bono attorney who's willing to handle the family court piece? And then I'll contact one of you. And you'll notice on the sign-in sheet that I asked if you were fluent in Spanish or had access to someone who was fluent, or if you needed me to find you a volunteer interpreter. We can do that. It's not a problem. We just like to know in advance if we need to do that, so we can pair you with a volunteer interpreter. And that may be done by phone. We have one attorney who lives a little bit out of the way, and we have paired her with a Spanish-speaking law student. So he's doing all that by phone. It seems to be working. So it works well. Legal Services of Southern Piedmont will give us a basic packet about the child that you will also receive as the lawyer, that tells you a little bit about the child, where they're coming from, what they're going through, and so you have an idea. You guys have any questions about any of that and how the process will work? Okay. And don't worry, we'll work with you on the family court piece. Mike and I both will, to kind of help you figure that out, help you if you have issues with the orders, which you'll notice in your packet. We have several examples of the pleadings you would be presenting in family court. We're not going to leave you blind. And we can both assist if you get really stuck and have questions. I do think that we're going to take a short break before Mike starts, maybe 5 minutes, so people can get up and stretch. And then we're going to turn over to Mike, who has a longer piece to present on. All right, thank you.
Oh, sorry. We don't need you to turn up with your numbers. We know you're not shaking one of these. If we could, we do it. Yeah, exactly.
Where'd you put that laser pointer? All right, guys, we're going to go ahead and get started. My name is Mike Pinilla. I'm an immigration attorney here in Columbia. I have a small office, which mostly means I'm pretty much here for the free snacks and coffee and stuff. So today I wanted to thank everyone that could be here today. I want to thank everyone who is joining us on the streaming in Charleston, and I think that my understanding from Tammy is that you guys are interested in taking one of these cases, or at least are signed up to take one of these cases. So I hope to provide everyone there's a lot of information, but I want everyone to have like a strong understanding of what is being done and how that is being done, and then how that can affect the child in question. And as you see, I mean, what you're doing here is a very noble thing. You're helping a child that's been abused, neglected, or abandoned. And those examples that Tammy gave you are all too real. Those are examples that we see over and over and over and over from different countries, but mostly from the Triangle, as Tammy said, El Salvador, Guatemala, and Honduras. So to kind of give you guys a broad overview and to see where this all fits in, the process that we're talking about is obviously a special immigrant juvenile status, and this fits into this wide ocean of immigration law. But to kind of begin, I wanted to give everyone an introduction. I apologize if some of you have had forays into immigration law. At any time, please stop me for questions, and those people in Charleston, please shoot them over in emails, and we'll be checking those throughout the presentation. So today we're going to go over some common immigration concepts, some common immigration vocabulary. As you probably heard Tammy say, SIJS, we use abbreviations for everything, much as like you do in any of your law that you're practicing. We're going to go over the overview of government agencies. What you'll see is the interesting thing about SIJS is that it just crosses so many different government entities. It crosses over so many laws, both federal, state. It goes over several thresholds. So these are common ways to obtain immigration status. You can do this first, and the most important is family relationships. Maybe you're married to a U.S. citizen, and that gives you a way to obtain an immigration status. Maybe you have a family member, a brother and sister, or mother or father that's a U.S. citizen, and that's another family relationship. Some of you may be aware of the employment petition. Say you have a large corporation that wants to bring over workers from Mexico or workers from Germany. Those are employment petitions that can get you a way to obtain an immigration status. A lot of you have heard the term asylum, and especially this year, refugees. Those are people that fear persecution or torture in your country. Then you have the big one that's bolded that we're going to be talking about today, which is the special immigrant juvenile status, and I'll be referring to it as SIJS. You'll see it commonly as well as SIJ. Some people say SIJ. I just go with SIJS. There are also ways for people to get immigration status when they've been victims of certain crimes and domestic violence and sexual assault. And then sometimes in the immigration court realm, you're linked in the U.S. can sometimes help you with the immigration status as well. So first is, what is a non-citizen? And just like the definition applies, a non-citizen is anyone who is not born in the United States. Anyone who is here on any type of visa is a non-citizen, whether it's a visitor's visa, a student visa, or some other type of visa. Anyone who is here with asylum or refugee is still a non-citizen. There is a pathway to get citizenship, but you're still considered a non-citizen at that point. Anyone who entered with a visa and then overstayed, those are also non-citizens because their status is expired. The most common form that we all know are undocumented. You just came over here, you crossed the border from Canada, you crossed the border from Mexico, or you came through Florida, some kind of way. Those are the most common that we deal with. And then there's the lawful permanent residents who have green cards. A lot of people have heard about green cards, but they're still technically non-citizens because that can be revoked with certain requirements. Now here's common vocabulary terms: U.S., born in the U.S., naturalized, which means that you were born in a different country, but you somehow were able to become a U.S. citizen down the road. You were born abroad, but you got citizenship through your parents, like I was saying. If you have a family relationship with somebody that can help you get immigration status, obviously the undocumented got shifted over, but that should be under the everyone else category, which is non-citizens, immigrants, aliens. All of those are synonyms for non-citizens. Now, when you start working these certain things and you do a SIJS, we refer to immigration attorneys just have a common jargon, and it just goes by the form number. We'll say we need to file I-360, or we need to file a 485 or I-130. So if you're talking to somebody and they say I-45, you can pull up the form and see it's an application to register permanent residence or just status. That's too long. We just say 485. the abbreviation every time. If you see abbreviations in certain briefs or things, SIJS is what we're talking about today, Special Immigrant Juvenile Status and United States Citizen, usually USC. And a lot of those letters are apportioned from the INA, and we'll go over that in a bit. We'll skip over the common jargon. Now, the federal government agencies involved in immigration processes, everyone knows the three branches of the government, so we won't go over that. But what's most important here is the Department of Cabinet, and I'll point over here with the laser pointer. Under the agriculture sector of the cabinet, you have Health and Human Services. Under the Commerce, you have Homeland Security. Under Education, you have the state education. Each state has their own education, and then Justice under the Energy Cabinet. And these all interplay with the Special Immigrant and Juvenile Status cases, and we'll learn about that a little bit later. These are our secretaries and their programs underneath each. Under the Health and Human Services, you have the Office of Refugee and Resettlement, which you'll be learning more about with this process. You have the DHS, the Department of Homeland Security. You have the USCIS, the United States Citizenship and Immigration Services. You have ICE under there. You have Customs and Border Patrol, all under the Homeland Security realm. Then you've got the Secretary of State. Underneath there, you have your U.S. embassies abroad, your consulates. You have your other programs to control trafficking. And then finally, under the DOJ, you have the EOIR, which is the Immigration Review, which kind of controls everything that's legal with immigration law, the immigration courts, the judges, the appeal boards. And then you have all the USAUs underneath that. Any questions before we move on to more of the substance? Okay. You got anything there? I'm going to get into what removal is, and this becomes important with these cases because what you'll see, the kids that you're working with, there are two types of children, and the ones that you'll be working with are the ones that are in removal. There are also children who are not in removal proceedings, and so what we'll expect to hopefully understand here is kind of the overview and the timeline of a removal case, which is removal is just another word for deportation case. So a lot of these kids are facing deportation when they come and they need your help. In the immigration court, there are two types of hearings, what we call a master calendar hearing and a merits hearing. There could be several master calendar hearings, and then there's only one merits hearing, and that's at the end of everything. Who's subject to deportation? Obviously, anyone who's a non-citizen can be removed by ICE. Anyone. What's most interesting here is if you have somebody that is in removal proceedings or facing deportation, they have a right to an attorney at their own expense. So at this level, there is no public defender. They don't. If you want an attorney, you have to be able to afford one. You got to be able to go to several organizations that are giving pro bono help out, and that's important for a lot of these kids because they're children. They have no money. They have no way of accessing any kind of legal representation. So most common reasons why somebody is put into deportation proceedings. The first one is several people will apply for things that they're not eligible for, like asylum, and they find themselves in hot water down the road. Most commonly right now is that you've been apprehended at or near the border trying to cross into the United States. And so what happens is instead of turning people around, now they're putting them through the immigration process. A lot of workplace raids. I don't know if anyone remembers here several years ago, the chicken plants got raided, and that caused a lot of work for the immigration courts. And sometimes people have issues when they come to the airport if they're non-U.S. citizens and they didn't know that they had a drug trafficking charge or a drug charge or some kind of criminal charge that they thought was cleared up and it wasn't, and you get to an airport and they say you can't come in. What I wanted to touch on here is in November 20th of 2014, I know it's a little small and I think it might be in the binders, the policies for apprehension and detention was updated by President Obama to include 4 types of categories that, 3 types of categories that will put you in removal proceedings. And priority 1 is usually the worst of the worst. Priority 1 is that people are suspected terrorists, they're suspected threats to national security, danger to the United States. And then underneath that is Underneath terrorists is aliens apprehended at the border or any ports of entry while attempting to unlawfully enter the United States. Now that becomes important because these children, and that's exactly what they're trying to do. They're trying to enter the United States unlawfully, fleeing away from the dangers that they're facing, and they're being placed in priority 1 category, which is right under terrorist. So it becomes difficult to represent them because they're priority 1. Now priority 2 are folks that have an old DUI or domestic violence order, so anyone who is been found guilty of certain criminal charges can be removed. And then priority 3 are other violations. Those most commonly are misdemeanors, and they end up finding themselves in hot water as well. But they're on the lowest totem pole of people to be removed from the United States. We'll get into that stuff. Now, the chronology of removal proceedings, and this is going to move from the bottom, your bottom left, up to the top of the triangle and down. And to see at the beginning, it's the initiation of removal proceedings, and we'll talk about that. There are charging documents that start a case. How does someone end up in removal proceedings? One of those violations, you start at square one. And then there's a bond hearing, if applicable, like in any criminal case, you have the chance to get a bond. Sometimes it's very difficult to get a bond because children don't have equities that bond courts will typically look at. Time of length in the United States, a family here, property, those kind of things. And so bond hearings are sometimes difficult for children. Then you have the master calendar hearing, and there could be several of those, and we'll talk about that in the next steps. Then there's the merits hearing. There's usually only one, but sometimes you could have more. And then a final decision by an immigration judge. That won't be. All right. So there are 2 stages of immigration proceedings. One is whether a person is actually removable, and 2 is what type of relief do they have. And that's where you will come in with the relief. If a certain child qualifies for SIJS, that is an affirmative relief, and that is something they can assert. The notice to appear is the charging document from the government that charges you as someone that could be deported from the United States. It's a formal document that's presented to you. There are 10 days notice. Once they give it to you, you have 10 days. They have to give you a court hearing after 10 days. And then the NTA, and I'll show you in the next slide, here's an example, is just a formal document from the government that alleges that you are unlawfully in the United States, that you entered unlawfully, that you're here unlawfully, that you overstayed a visa. And then the factual allegations go in the middle of the document. And those are that you did not enter the United States legally. It just depends on your case, that you crossed the border in El Paso, Texas on January 2015 or 2016. And underneath the charges are the INA that you are being removed under, and the certificate of service is supposed to be signed, and that they serve this on the actual person before starting their deportation proceedings. A little close-up of one, you can see the top of it is where your name goes. It's always in the matter of your name, your birth date. And the file number is what we refer to as an A number. An A number is an alien number. It's what it stands for. Every person that comes into the immigration system gets an alien number. Every person is like a Social Security number. You only get one, and that's yours forever. So if you ever encounter more than once, you'll still have the same alien number. Again, here, this particular one from California that I found says that you entered the United States, but then you're removable for the following reasons. Sometimes the most common ones that you'll see is that you're an arriving alien, which means that you have just arrived unlawfully, or that you have been here some time, which is option number 2, that you're present in the United States without having any kind of permission to be here. And so underneath will be, as you can see, the Department of Homeland Security alleges that you're not a citizen or national of the United States, because if you were, then you obviously would not be in deportation proceedings. That you're a native of, pick any country outside the United States to fill in the blank there. It could be Mexico, Honduras, Germany, it doesn't matter. And that you're a citizen of that same country. This person actually came in through New York with looks like a RE8, which means they're a refugee, and then they naturalized to become, or they became a lawful permanent resident after that. And this person was convicted of a violation in California. So these are very common. We see these very often. They're just tailored to the law, for the state that the person was arrested in. But like I said, mostly what you'll see is that you're just an arriving alien, or that you're an alien present without being admitted, and then they'll go with those type of charges underneath. Any questions before we move on? Okay. Now, 3 categories of aliens, like we just said, were arriving aliens. Those are people that are seeking admission to the border. Sometimes what we've seen most commonly are children that have, as Tammy mentioned, it's a life-threatening and dangerous journey to come to the United States, especially if you're coming from, let's say, Guatemala. Because from Guatemala you have to enter into Mexico, and in Mexico you got to get through to the United States, and that is hard on its own, but it's also hard for certain Guatemalans to get into Mexico. And sometimes when the kids get to the border, they turn themselves in. They just want help. They just want safety, and they're tired and they're exhausted, and so they are seeking admission at the border. They find the nearest officer and say, "Here I am. I came unlawfully from Guatemala, Honduras. I am seeking admission to the United States." And what usually happens is the child is then taken into a home for other children with other children that have come in unlawfully, and they're issued an NTA. Sometimes they're able to bond out without any money. Sometimes they have a family member they can reach out to post a bond, and that starts the removal process for the children. Another type of alien is those without admission or parole, those that have entered without encountering any type of ICE agent, any type of government agent, and they're just living here, and then all of a sudden they get in trouble for something, and now ICE and Homeland Security knows that they're present here without permission. And then the third category are those that have been lawfully admitted, that you entered with a green card, that you entered with a visa, but now you're deportable because of some reason. Burdens of proof. As lawyers, we like to talk a lot about the burdens of proof. Here it's pretty easily. Any non-citizen must prove clearly and beyond a doubt entitled to admission, and it is not admissible. So the burden is always on you to show that you have some reason to stay in the United States, that you have some way of staying in the United States lawfully. When we get into the immigration realm, we talk about 2 different types of deportations, whether you're inadmissible or whether you're removable. The most easiest way to remove this is if you're removable, it's because you've already entered legally, and now they're trying to take that right away from you to reside in the United States legally, and that makes you removable. Inadmissible means that you have just arrived, that you do not have any way of staying into the United States lawfully. You have no family that's a U.S. member. You have no parents or brothers that are U.S. citizens. And so those people are inadmissible from the beginning. So those of us that will go to immigration court, we will study the NTA, the notice to appear. We'll make sure that it's factually correct. We'll make sure that what they're alleging is correct. We'll make sure that, if there's a criminal charge on there, that they've actually been found guilty of that charge, they've been convicted of that charge. So when looking at the NTA and when you first encounter the judge, what they're going to want to know is whether you admit or deny. It's like a complaint, and now you're answering the complaint. You say, you admit paragraph 1 and 2, but you deny other paragraphs. Maybe you weren't found guilty of a certain crime that they have alleged, and those kind of things. And what the judge will want to know is the designation of your country of removal. This becomes somewhat intricate, somewhat difficult, because if you have a child that is from Guatemala, that is where they're from, that is their nationality, but sometimes they may request to not be removed there because their situation is so bad. But then the problem becomes whether they can lawfully stay in another country, but mostly here, if you're Honduras, they will designate that country as the country that they'll return you to if you are found to be deportable. And then the most important part at the immigration court, stages, the judge is going to want to know what type of relief do you have. If you're married to a U.S. citizen, you say, Judge, I'm married to a U.S. citizen, and that's how I'm going to fight my case. Or you say, Judge, this child is eligible for SIJS, and we're going to try to do that process. And what usually happens, the judge gives you an extension, gives you continuance to allow you to start working on that. The pleadings in immigration court can be oral or in writing. Most times it's easier to do it in oral with time constraints, but again, you just go in there and hear examples. You'll say, you admit allegations 1 through 5. You designate your country, Guatemala, wherever the person is from, and that you're seeking SIJS, or you're seeking asylum, or you're seeking a petition through a family member. The fun part about all this is the government has a chance to amend the original notice to appear, the original charging document. So even if you allege these things, they do have a chance to amend these things. Okay. A master calendar hearing is quite honestly pretty much like a quick status conference. You have all the attorneys in a room, and you have all the clients in a room, and the judge just moves right through them, just one at a time. Just, this is who this is, what's the relief, do they have any kind of eligibility to stay here, and they set over another date. It's very quick, it's very fast, it's just a couple of minutes once your case is called. The merits hearing is the actual meat and potatoes of the case. This is where you have your trial. This is where you put up your witnesses, you put up your client, you can enter documents in, you can present any kind of expert witnesses, those kind of things. You do a closing, you can write briefs. It's very, very normal, very what we're used to. Again, the burden of proof is on the non-citizen to show that they're eligible for that type of relief. Again, these are main forms of reliefs, and as you see, the one that is bold is the one that we're going to be focusing on today, which is the special immigrant juvenile status. When there's no relief, you can either take a voluntary departure that you're willing to leave the country on your own merits. You are going to pay for yourself to return, or they can remove you forcibly, or sometimes we have what we call prosecutor discretion, which is important, especially for children, because if you're not able to get the special immigrant juvenile status, if the child has a particularly difficult case or particularly just sad case, and you can ask for the government attorney to just close the case, leave the child here, and let him continue living his life without the fear of deportation. It doesn't make him able to stay here. If they are subsequently arrested for some type of crime, they could be redeported. But at least at that time, if they have a case that is very sentimental or sympathetic, then you can at least approach the government's attorney to ask them to just cancel those removal proceedings against the child. Any questions before we move into the actual SIJS? Now, this is going to segue into the type of relief that we are hoping to get for this child, hoping to get for some of the examples that Tammy gave you on the type of children that need this. Again, the main law, what is SIJS, is children who have been abused, abandoned, or neglected in the U.S. or abroad. The most common you're going to see is abroad, and those children have come to the country unaccompanied by any parents, and this is what I want you to take away from this today is the interplay of all the immigration law, of the international laws dealing with children, and the Hague Convention, and then the state law for the state that you're practicing in is going to be South Carolina, obviously here. We take all that into consideration when we're doing an SIJS case. These are the laws that enact SIJS. Most importantly is the INA, the Immigration Nationality Act, under Section 101A27J. You have several CFRs that apply. That's no longer INS, but you have ICE memoranda that apply to these type of cases, and then you have your state law that defines abuse, abandonment, and neglect. Now, just to jump right into family law, I have not been able to find anything in our law that defines abuse, abandonment, or neglect. It's just kind of one of those things that you just know it. DSS knows it when they see it, and you can present it to the judge, and the judge makes his determination or her determination on whether the child has reached those levels. And then you have the conventions on rights of children that you deal with. So, going back to the slide that had the government departments, what most commonly happens when a child enters the country is they are found by the Department of Homeland Security. They either turn themselves in, or Homeland Security is able to catch them at the border, and then they're transferred over to a housing unit for other juvenile kids that have tried to enter the country. And then the Office of Refugee and Resettlement, that's the Department of Health and Human Services, will try to find placement for this child. And again, most commonly, the child has a mother or a father here, and they want to be placed with that. Or sometimes, if they don't, they have a distant cousin or brother. And so the Department of the Health and Human Services, they will reach out to this person. They'll give them, it's a pre-screening that's done on this person that wants the child. They check their criminal record. They checked to make sure that this person can actually afford to have the child. And then a plane ticket is sent, and the child, if not having to post a bond, is released to the person that's going to care for them at that time. SIJS is rooted in what we call the TVPRA, which is the Trafficking Victims Protection Reauthorization Act. This was effective in March 23rd, 2009. So SIJS is something that's been around for a while. It's not that nothing that is too new. It is new to a lot of judges here in South Carolina, and so our job is to present it to them and hopefully make them understand what this process is and where their authority to grant the specific findings that we need come from. Most importantly, there was some amendments made to the TVPRA where now the juvenile court, the family court, only requires that the court find that reunification with one or both parents is not viable. Prior to this amendment, you had to have a finding from a family court judge that neither parent could have the child, and that was sometimes difficult because it limited the relief to only kids that had no parents. And so here, now if you can just find that either mom has abused or abandoned or neglected you, or father has done the same thing, that is enough to receive SIJS. And what's most important, what I'd like to mention here, is that SIJS is only for the child. So if you have a mom that is taking care of this child and father has abandoned this child or has abused this child or neglected him, mom receives no benefit for this. It's only the child. So the child is the only one that receives the benefit, and the benefit is being able to stay in the United States. The other benefit is being able to become a green card holder. So it's very life-changing for these children, so they can study, they can continue studying, and so that's important to know, that it only helps the child. So the basic law of SIJS, there's 5 basic requirements that we'll go through. And before we jump in, are there any questions? No? Okay. Requirement 1 is that the child be under the age of 21. What's interesting in the immigration realm is that you're still a child as long as you're under the age of 21. However, as you may know, once you're 18 in South Carolina, you're an adult. Same thing, that's important for the family courts, because in South Carolina, there are, once you turn 18, you're no longer in the jurisdiction of the family court. You're now an adult. So it's important that if you are going to try and request SIJS, that you do so before the child turns 18. And that becomes important because sometimes you'll have kids that are 3 months away from becoming 18 and they need help, or they've arrived to the United States at 17. And so that you have to keep that time frame in mind. Now, I know that there are some states that you're able to extend that 18, but I found in my practice here in South Carolina that once a kid turns 18, there's not a family court judge that's going to continue jurisdiction of a child over the age of 18, unless, of course, there's some terrible physical or mental disability.
And just so you guys know, the kids we'll be sending you won't be anywhere near age 18, due to how the grant is set up with LSSP. So we won't worry. Don't worry, we won't send you someone who's like 17 and a half or anything.
Tammy will just send those to me. Requirement number 2 is that the child is actually unmarried. This is interesting because you have some countries where children are married off at a very young age. So you have to know that if you have a 14-year-old female child who has been married off, they're not eligible for SIJS, unfortunately. But the interesting thing is, if that child has a child of their own, they're eligible for SIJS. Also, if the child becomes divorced or annulment or any other type of dissolution of marriage, they're then eligible for SIJS. So keep that in mind as you take a look at who your child is and who you're helping. Deprived under state law. This is where the family court comes into play. You have to have, the way that the statute reads is, you have to have a child that is declared dependent from a juvenile court located in the United States. That means that some judges will say, well, I don't know where I have the basis to find these certain findings that you need for SIJS, and you say, Judge, well, here's a copy of the INA 101 A27J that says that any juvenile court located in the United States having jurisdiction of that child can find that this child is dependent on a person. Now, what's most interesting, and you have two different kinds of dependency. You have children that have entered DSS because they have absolutely nobody, and DSS would be the agency or the Department of State that has the custody, but the court can find that the custody can be with an individual appointed. So if you have a mother, you have a cousin, you have a brother that says, I want custody of this child, then you are asking the court to just give you custody, to give custody of the child to the person that wants them, and they will find, again, under the INA, that this child is dependent on this individual. Requirement 4 is what we're talking about, the reunification when one or both parents is not viable, but that non-viability has to be based on abuse, neglect, or abandonment, or other similar basis found in state law. That is most important, and I've written caution on this slide because if you just have an order that says that cannot return to father, period, that will be, and we'll talk about it because once a family court order, and I've neglected, I apologize, SIJS is largely a two-step process. The first step is rooted in state law, and the second step is rooted in federal immigration law. So the first, you can't move to the second step without having this special order from a family court judge that addresses these things, that the child is under 21, the child is unmarried, that the child is dependent on usually the plaintiff, which is a family member or somebody that wants to take custody of this child, and that this child is not cannot be reunited with one parent or the other parent or both parents because of abuse, neglect, and abandonment. Now, you have to hit that reason, and some of those things and some of those examples that Tammy gave you may have a child that is being forced to work. You may have a child that is being abandoned, doesn't have a place to live, and is largely homeless. You might have a child that is being abused terribly in their country, and so you have to put the reason, you have to link it back to one of those three things, abuse, neglect, or abandonment. The interesting thing about SIJS is it does not require termination of parental rights, so you're not asking for TPS, which makes the legal portion of the family law so much better, because then you don't have to worry about removing a parent's rights to be a parent. You're just saying it's basically a super custody order where you're saying this is custody of this person because they cannot return to this person based on abuse, neglect, or abandonment, and why. And the fifth one, and it goes probably without saying, is that this is where a lot of judges get a little hung up on this, is that they have to find that it is not in the best interest of the child to return to their home country. So the judge has to say, Jose can't return to Guatemala because he would be subject to further abuse by his father. He would be subject to further harm by local gangs and delinquents. He has to find for some reason why that child cannot return to their country. Any questions about the 5 requirements? Okay. Now we're going to move into who cannot apply for SIJS. Obviously, as you know, any child that is married, you can't have a child that has certain felonies, a child that has done, some kind of crime. You can't have a child apply for SIJS if they've got a traffic control if they've got a substance trafficking charge, or if they're engaged in terrorist type activities. Obviously, those are the kind of children that the government does not want to help. Now, there are certain things that can be waived. Say you have a child that is a drug addict. I had a very sad case of a child that was had no family. He is from Honduras, and his mother passed away from AIDS, and his father was a terribly abusive person to him. Kicked him out of the house at the age of 13, and he was homeless for about 2 years, and then he fled to the United States. But in those 2 years, he got addicted to drugs, and unfortunately those are kind of things that happened. And so if you apply for SIJS, there could be an issue with being a drug addict or a drug abuser. Also, as you see here, if you have some kind of if you're an alcoholic, or you have some kind of mental or physical disorder, or if you've been forced into prostitution or some type of commercialized vice, these are things that can be waived. And what that means is that there is a waiver available to the child to say, these are things that have happened to me, but I should still qualify for SIJS. And so just keep in mind that, not all children are perfect, and, sometimes they've had a very rough upbringing and cause some of these issues, and that does not disqualify them from receiving SIJS. So, one of the things you may be asking yourself is what needs to be done to begin SIJS. Obviously, the first thing is filing a family court action, and just by a show of hands, have anyone done family court work? Okay, good. So, I will now turn to the notebook here, the binder that everyone has. The first step in a family court case, like any civil actions, if you have your civil action cover sheet, you have your family court cover sheet, your summons, your complaint, your verification, those things. There is a complete template on number 8, and this was prepared by. Okay, this is something that's out of Charleston, so a complaint is something that you can mine very, very much from this, but this is a very good complaint. As you see, it says this child is residing in certain county, whether it's Lexington or Richland County, on page 1 there under number 8, has been abused, abandoned, neglect. You can pick one or you can pick all 3. Sometimes it's all 3. Sometimes it's very clear, but you have to at least allege one of those 3 to qualify. And then, up top, the plaintiff is usually the guardian, usually the person that says, I want custody of this child because I don't want them to return to the country. And up top, the defendant is either the mother or the father or both. And then it goes under to explain why. You give the background. The child lived in Tegucigalpa, Honduras, and his father lived there, and they resided with his father, and that the child fled to the U.S., and they were encountered by ICE. This is a good, and then on page 3, you start getting into your relief, and you start getting into why it's not in the best interest of the child to return to the U.S. That is how you start the SIJS process. It's a civil action that's filed in family court. Now, with the civil action, there is always service, and everyone's very familiar with service, and that's where things get tricky because 9 times out of 10, you're going to have a defendant that lives not in the United States, and you have to find a way to serve them, and under the rules, you have to serve them personally. So, sometimes it's the father, the child doesn't know the address, or the child was abandoned by the father years ago, and they have no idea where they live. You still have to follow the normal rules of service. You got to do a order of publication, or you have to send a process server out there. You've got to work with somebody. Tammy, are you taking care of service or? Okay, so you have to be very aware of those things. Sometimes you have a father or mother that's in the United States who's the defendant, and that makes it a little easier to track them down. But usually what I try to do, if possible, sometimes you have a father that says, or a mother that says, I just do not want this child. I don't care who takes him. I am willing to sign whatever because I don't want anything to do or any responsibility with this child. And so what I try to do, and we we have put this in the binder. It's under tab 17, if y'all could take a look here. 17, there are two examples of, and this is all in Spanish, I don't expect anyone to read it, but this is just a certified custody agreement to give that this parent is signing over custody to this other person. And what I'll have them do is take this and get it notarized and make it look very official. And you see there on the second page that the notaries in other countries are much more serious than they are here. And then have this translated by somebody and have that as the service. Of course, if you can get an acceptance of service, you should do that. But the service portion is very important because any judge for any type of case is going to want to make sure that the defendant was served. Now, with that, once you have the service, you need to move into the temporary hearing. The temporary hearing is just that. It is it's a status conference. You make a motion. You make a motion for a temporary hearing, and that is going to be on number 13. And you're saying you want this person to have custody. You want the judge to be familiar. Now, what I like to do, and if time allows it, it's because there's certain judges that, hopefully Tammy and Appleseed can point you to. If you have a case, an SIJS case in front of certain judges, they already know what it is. You just have to go and explain the case. Now, you have other judges in smaller counties that do not know what it is at all, and they are not, they're used to seeing divorces all day and all night and custody cases all day and night, and then you bring this thing and they're like, what in the world is this? So what I like to do is, if possible, file a brief with the court. And that looks like it's under 16. That's not right, is it? No. That might be out of order. Did you have a brief in there, Tammy?
Yeah, there should be.
Well, 16 is not the brief, but I think that Tammy does have a link of an example brief for you. But it is always good to write a brief and kind of explain to the judge basically what we're doing here. What is SIJS? Where does the authority come from? What has this child suffered? Why is it in the best interest? How is he doing in the United States? Is he a high school student at AC Flora? Is he learning English? Do his teachers like him? Is he getting good grades? Those are important things for the judge to know, and it always helps you out if you can have the brief filed before you go into the hearing. Now, what I like to take to judges that I'm not sure whether they know what SIJS is under 16. Everything under 16 is everything that SIJS is. I just copy this and I take it to the judge, and if they have a question, I say, Judge, here it is, and this goes over everything that we just talked about. What's most important is what is the role of the juvenile court. This is actually from USCIS, so it's an official document. It's nothing that I've created. It's something that is out there for family court judges to look at. And of course, on the third page there, I give them the SIJS statutes. I give them where the law comes from for the juvenile court to make these determinations. And okay, great. The brief is under tab 15, third page. You can take a look at that. But I think what's also most interesting in our area, sticking with 16, is some of the news articles that have come out on children that have entered the U.S. And, although this is just at the governor level, the mayor level, Mayor Benjamin has adopted and made a resolution for these refugee children. And refugee children is just another word for potential SIJS children, especially if they meet these 5 basic requirements that we talked about. Now, finally, do we have an order? Let me see. Next one, template. Now, when you get into the court, you have to, once you get a temporary order, then you should move it into a final hearing. You move it into, I guess, ex parte relief, because the defendant is either not going to appear, or they will appear, or they won't, and they just agree to the relief. And you have to have your order. Now, under 16, there's a basic order, but that is pretty much what I present to a judge. And if a judge is willing to make those findings, or you can make the language stronger depending on the case of your child, if you have you want the judge to know about sympathetic situations of the child. Child was forced into prostitution, child was impregnated by a way older man at the age of 14. Those kind of things really ring loud with the judge. And so you put your order together, you present it to the judge, and he signs it, you clock it, and luckily your job is done and you've done a really good thing. But what I want everyone to know is where that order goes. So the order goes to an immigration attorney, and the immigration attorney then files it with several immigration forms. And the reason you want your order to be as good as possible and as detailed as possible is if you look under tab, it says 19 here. Do you have a tab 19? Mine's under 18, yes. If you go under 18, if you look at this is an actual case that I did, and I received from USCIS in Charleston, South Carolina, a notice of intent to deny. And so if we just take a look at it, just cursory, Part 1 says that I filed a Form I-360. The I-360 is the form that you apply to receive special immigrant juvenile status. And to backtrack a little bit, what you want your family court judge to know is that the judge has not granted this child any type of status in the United States. The judge has not given this child anything. The only thing that the judge is doing by signing this order is allow this child to actually apply for this type of relief. So if you have a judge that, well, I don't have this kind of judge. The only thing you're doing is giving this child the ability to actually apply for this. So then the immigration attorney applies, takes the order that you've received from the judge, attaches it to this form, and sends it off. And then sometimes you receive these things where it says under Part 2, you were born in Guatemala. You filed an I-360, you were unmarried, you're under the age of 21. You got an order from the Family Court of the 11th Judicial Circuit in Lexington, South Carolina, and it states that reunification with your mother and father is not a viable option because they cannot keep you safe or are unwilling or unable to support you, etc., etc. Third page, it goes down to say that your order is temporary. That is the issue. And luckily, you won't run into it when you have a kid that is going to turn 18 years old and you're only able to get a temporary hearing. So if possible, I strongly recommend if you go to family court order under a temporary hearing and you have a judge that's sympathetic to SIJS and sympathetic to your child's case, you might ask them to amend it to a final hearing just right there on the spot. I've had some good success with that. And so a judge will make these determinations on a final matter, and that was the only issue. And luckily, this case was easily fixed. You just get the judge to amend the order or go back for a quick hearing. But these are why you have to be careful with the words that you use. And if you look at the bottom of page 3, they really attack this, saying that the temporary order is that you're acting in loco parentis, which is tough because in loco parentis is usually only used for schools, and so any way that the government can attack your order, they're going to do it. So I want you to keep that in mind because it really helps out the immigration attorney in the future when they're using your order to forward it. So you want to make sure that your order is as strong as possible. Okay, let me see here. Under tab 18, if you go past the notice of intent to deny, on the 5th page is one of my actual orders, and this one had no issues. The next one has another redacted order, and so feel free to use those things. I always like to include where the law is coming from that the judge is using to find his orders, that is the civil court portion of SIJS. Any questions? Yes.
I'm concerned about the service issue, how that is accomplished.
Listen, I will give you my contact information, but you can reach out to me, and I'll be happy to help you with that. Or
The other thing we've been doing is, because there are low-income children involved, one of the professors at law school actually helps us and advises us on the best way to do service for no charge, because it's all low-income children. And he's very good about, this is the best way to do it. I've used actually his advice in court and said, Dr. Samuels told us to do it this way, and it's been fine with the judges. So we can also make that connection.
It's a very good question. Service is very difficult, especially have, again, out of the United States defendant. What I find best, and you really will have to press your guardian, your plaintiff in the case, and I think, I'm sorry I stepped out, Tammy. Did you talk about interpreters?
We will partner them with a pro bono interpreter.
Okay, and so the communication, you just have to make them know. And I've had several plaintiff guardians that say, we don't know where this person lives. We don't know, he's in Honduras somewhere, she's in Honduras somewhere. We have no idea, and you just keep pressing and pressing. Do you know his family member? Do you have an old address? Do you have something? And you'll find it's very funny. They'll end up finding a telephone number, and that gives you enough time to give them a call and say, this is what we're doing. Are you interested in any type of custody of your child? No, I'm not. Are you willing to sign this document? And usually you say at no cost to you, because the guardian will pay for it, and they will sometimes are willing to. Now, if not, remember, as long as you've done your due diligence, you can always do an order of publication. I don't know how that's going to work with the fees involved with the child, but I have done order of publications in other countries, and you'll find that a lot of the newspapers in those areas do speak English, and if not, you can always use a translator and set it up that way. And what I do with the order of publication, I always publish the summons in English or Spanish, and I'm sure Appleseed will help you with the translation of a summons. So those are things, but the good thing is, because you're dealing with children that are way under the age of 18, you have time. You have got a year from the time that you file the family court action to have this served and have it moved to a court order. So as long as you do your due diligence and you check, there are ways to serve it that don't have to be personal. I always go for personal first, because that's obviously the quickest and the least amount of headache involved. But I wouldn't be discouraged from doing this just because of the service issue. Any other questions? All right, can we take a break before we? All right.
I don't see any emails from Charles and crew about
We'll let them catch up and see if there's anything.
they're on delay.
How about 10 minutes? Okay, great, thanks.
You can have mine.
Oh, no, I just, okay. So I can ask Laura, just shoot it for later.
It's just me. It's also not us.
Okay, thank you.
I have access to all.
Thank you very much.
All right, we're going to pick up again. Tammy has just mentioned to me that a lot of this SIJS law has been incorporated into the family court's bench book. I don't know if you want to say a couple words about that.
The family court bench book, and that is posted on the Children's Law Center website. So the judges are supposed to be familiar with it. It is for family court judges. And I typically, me and another attorney, usually train the family court judges on this, if not every year, every other year. So they should know about it. I say they should know, but they should. And it is in the bench bar book that all the family court judges have access to.
Okay, so just to go back and kind of recap everything, and I understand that it's a lot to take in, and it's a lot of new things, but I want to really have everyone understand where this fits in. So as we said, you'll have a child. Are the children removal proceedings? Okay, you'll definitely have a child that is in deportation proceedings. They've been given their NTA. They're arriving aliens, and they have an immigration attorney. And so the way that I'm envisioning this, and the way that it usually happens, is that this child will go to immigration court, and the attorney for the child will say, we are going to seek relief under the SIJS. And then the judge will set it over for another court date and consult with one of you guys to start the process. Now, again, just remember, SIJS is just one form of relief. It's just one way to keep the child in the United States. It's just one way for the child to become a green card holder, so the child can then live his life here as a permanent resident, and hopefully in the future become a U.S. citizen. So are there any questions before we move on the recap? Okay, so again, like I said, this is just one thing, and the only thing that you have to focus on is the family court aspect of the SIJS petition, and that is, it is the most important part. So again, it's just a civil action. You're just convincing a judge to find these certain things, and again, those certain things are that the child is unmarried under the age of 21, that the child has been abused, neglected, or abandoned by one or both parents, and that the child's best interest to remain in the United States because they're subject to some type of future harm if they are returned to their country. So really a lot of what it is just lawyering and being an advocate and presenting your child's case. Again, you just have to meet the usual requirements in a civil action, as we talked about, service and those kind of things. So again, just to kind of, I know I threw a lot at you, and that's it's because there's a lot of time, and so I just kind of wanted you to understand where it was coming from, what you're doing, and then where it's going. So that is it in a nutshell. Is just a civil court, family court action, and you just are asking the judge to find these particular findings. And as Tammy mentioned, you have a lot of weapons in your arsenal here. You have access to all the materials. You have the binder, and you have the family court bench book. And so you could print that out and take it to the judge and incorporate it in your brief. And like I said, the brief is important, and it doesn't have to be anything long, no more than 4 or 5 pages, and just kind of give the judge the background of what it is, what you're looking for, and why you're looking for it, and then have that order signed, have it filed, and then you ship it off to the immigration attorney, and hopefully that will be the end of your good deed. Any questions before we move forward? Okay, so what happens if you're not approved for SIJS? Don't be disheartened. There's still other things that could be done. The child could apply for asylum, and again, as we talked about, you can the immigration attorney, if the case is sympathetic, could ask for the case to just be closed. And so at the end of the day, if you do the best you can do, and it doesn't work out, well, at least you've done the best you can do, and hopefully there's something else that the child can do. I don't know if it'll be necessary for you to be a witness in any of the things that you've done, but a lot of the pleadings will sometimes be necessary to be turned over to the immigration attorney. And again, I think the most complicated it could become is that you have to go back to court to have an order amended or have something added into it. And, the judges that have signed those orders are willing to do that, thankfully, and so it shouldn't be a problem. But again, that order could be incorporated into a written brief by the immigration attorney. And so I just wanted to let you know that there, the living document of the order will just continue. These are motions that we won't go through today. Yeah, the interpretation. Yeah. And so at the end of the day, if the SIJS status is approved, the immigration judge will give an order saying that this child is found, that he found this child has relief, and I believe it's in here. Let me try to pull it up real quick. I saw it in here when I was looking at it. Let me take a look. Jeez. The last page under tab 17 is the actual order of an immigration judge that found that the I-360, again, is just the form name for special immigrant and juvenile status, that the I-360 had been approved and the case is being terminated. That is the end result of your hard work, and that is what you want to strive for, and that's what the immigration attorney hopes to have at the end of the day, is that order from the judge that the case has been closed. Again, just to... Sure.
Charles, the people are saying they're concerned about service,
Mm-hmm.
and they want a general timeline of filing service before the temporary hearing,
Mm-hmm.
and they want kind of just an overview of how long all this takes in family court.
How long it takes in family court is kind of dependent on really you and your circumstances, but that is a great question. So when you file the civil action, you have 1 year, you have the 365-day deadline to complete the case. So that is your time. That is the amount of time that it can. That's the longest it can take is 1 year, 365 days. And actually, when you file the family court action, they'll put a big stamp on it that says this is subject to 365 days. So from the date you file it, if you file it July 19th, 2016, you have until July 19th, 2017 to complete the case. So once you file the action, then you need to move directly into service. Service, again, that is going to be one of the most complicated things, but it doesn't have to be. Again, you need to really interview your client. You need to really interview the guardian, the plaintiff, to see if they have a last known address, if they have a telephone number so you can reach out to them and see. And again, I have found in at least 75% of my cases that there is a parent that just will be willing to sign this thing away and give custody to another person, and then I can help you, or Tammy can help you, or one of these examples can help you in that. But remember, if you have a last known address and you've tried to personally serve it there, then all you have to do is make your motion for an order of publication. And I think it's the same in any civil realm. I apologize, I don't do civil work except for family law things and immigration. So you ask for an order of publication, you show your due diligence, you have an affidavit from your client saying we believe that the person lives here because his family members have told me, because Facebook has told me, because Instagram has told me. And so, between getting an order of publication and your first service could be about 30 days, 45 days. And once you get your order from the judge that you can actually publicate in a newspaper. And now to find a newspaper, you can just ask your client, what paperwork. So you can Google it. I've done that very often. I don't know who publicates in this little area of Guatemala, and I will find the most recent one that circulates it there, put it in the order. And I have found that judges, as long as you've done your due diligence and as long as you have your affidavit from your client, that they will approve the order of publication. And then you approve the order of publication. It's got to run consecutively one time a week for 3 weeks. So we'll say that's another 30 days. That's 2 months. And then once you have that back, then you can move to your temporary hearing, or you can move to your final if you have all your dots and crossed and everything checked off. And then the final hearing in a family court case, If you're using an interpreter, I always like to ask for 30 minutes or at least an hour if you're going to have witnesses. A lot of judges will want to streamline the process, and so that's why the brief is very important, because if you file the brief and you show what the guardian is going to testify to about what the child has suffered or what the child has experienced and the future harm that this child could experience if they're returned to their country, then it makes it a lot easier to know where the hearing is going to go with the family court judge. And I always try to take the family court order ready if possible. Any changes can be handwritten in, but you want to have one of your basic format that is in the binder on what you're finding, whether it's based on abuse, neglect, abandonment, or all three, and then what it is that the child has suffered. And sometimes it's very sensitive, and you can just generalize it, subject to further harm, further sexual harm, further assault, further abuse by local criminals, but you do have to have something in there so that when the order is presented to ICE, to USCIS, that they have to see that there's actually an order that was found in basis on SIJS. So you could have an SIJS case that quickly could take 4 months, and it could take as long as 7, 8 months. It really just depends on the circumstances of the case. Sure.
How do we find process servers in these countries?
Honestly, what I do most economically is usually, again, 9 times out of 10, there's always the exception. If your client is the child, but also the mother who's the guardian, and she knows a person or a friend or somebody that you can mail the documents to and have that person personally serve the father if you have the address, and then that person goes and files an affidavit with the notary and returns it to you. You have it translated, and that has always worked for me as personal service. There are companies that do international process serving. I can get you the information of one. I don't have it with me. I did call them on one occasion, but it seemed to take a very long time. They said it could take up to 5 or 6 months. So, but if that is your last resort, then I think that that's what you should do. At least gives you another 5 to 6 months to complete the case. But I can get you that information.
If you're calling the other parent or one of your staff, do most of them, you mentioned a lot of them seem to be receptive to just signing off on service. Are there certain things your staff is saying, or is it just they recognize the child has a better life in the United States?
I think it's a little bit of both. A lot of people that have abandoned or just neglected their child and just left them to the wayside, they have other family now, and they have other kids and other spouses, and they are realizing that, especially if you say this is what, and the thing is sometimes the child is, what's the word I want to use here? The child is subject to abuse by gangs and local things. I mean, we've had cases where gang members are throwing rocks at these children. I mean, I have kids that get beat up, that get their clothes stolen just walking to school. And if you have a parent that abandoned this child years ago, they don't know. And you explain those things to them, and you say, look, this is the only chance that your son, who you pretty much have done nothing for, has to reside in the United States safely with his guardian, whether it be a mother or a distant family member. They are receptive to that. Sometimes they're not receptive to it, but at least if you can get an address before they hang up the phone or a telephone number, then you can try to personally serve them through another person or through one of these agencies. Any other questions on that? Okay. Now, there is an appeals process in the immigration realm. Again, if anything is dealt with it, it'll be on the order, but the immigration judge will say the order is not sufficient, or maybe it was denied, and then you can appeal it to the BIA, and you can appeal it to the Fourth Circuit, and then if it merits to the Fourth, to the Supreme Court.
And just so you guys know, I've never heard of someone getting turned down for an SIJS order in family state court. I think Mike had one that was close to aging out, and that was a problem. But your kids won't be there. You won't be near 18, so that won't be an issue.
Again, as long as you present your case in a very sympathetic way, as long as you have got your service things underway, I've found that 90% of the judges are receptive to that, and they, again, luckily through the work that Appleseed has done and Tammy has done, the judges are somewhat familiar with the case, at least, if not completely familiar, and so they won't, it's not like you're being thrown to the wolves. They're not going to beat you up pretty bad, and the only way that you'll have an issue is if you have an issue with notice, with service. That is really the only thing that I've ever come across, but usually, again, most judges are pretty sympathetic to this. The appeals process, again, that would be for the immigration attorney, and then, again, unfortunately, if there's nothing a child can do, that they will be given an order of removal, or they'll be taking a voluntary departure, which again means that this child is somehow going to return on his own money, and having documents to return, and the final order's removal. Again, I guess what I wanted to impose on everybody with the slide is that if a child is found removed, they're inadmissible to the U.S. for X amount of years, whether it's 5, 10, or 20. So the stakes are pretty high for these children, especially for the ones in deportation proceedings. And so, again, I'd like to thank everybody who is taking one of these cases, because it certainly is necessary, and it certainly is a good deed that you are dramatically changing a child's life. That completes my slide, my PowerPoint. This is my contact information. My email, everyone loves email. That is the best way to get a hold of me. If you have any questions at all, even if you think it's not important, yes.
When you file for the temporary relief, do you have to provide management? Do you have to go through the same service issues to provide management?
So under the family court rules, the only personal service that has to be done is the complaint, the summons and complaint. And so the temporary hearing, you can actually just serve it to the last known address. And then if you have an order of publication, I think I have found that has cured the serving of the temporary hearing. Good question. Again, like I said, if you have questions on, if you want to look into using an international process server, or again, I can't emphasize enough that you just have to interview. You'll see, and it gets a little bit frustrating at times, because you're trying to help somebody, and a guardian is not giving you all the information that they may have, but there are ways to track people down that they know through their family, through the other parents, family members, and when you're talking about a child, unless for some reason you're absolutely opposed to helping your child, they're receptive to listening, at least, and understanding what is going on, and especially when it doesn't cost them anything just to go to an office and sign a piece of paper and have it notarized. So, any questions? Are there any questions on the family court realm, on anything, on presenting the case? Okay.
And your binder does have a lot of samples. Also, the Dropbox link has samples, and I'll resend that link out. Samples of tweeting, samples of how to do things. And it sounds like it would be helpful if we could find some resources for people on service of process and upload it so that people all can have that.
Again, acceptance of service. Remember that we have an acceptance of service, and so if you have a family member that says, "Yes, I will sign." I mean, I like to get the custody agreement, because it just makes it easier for the judge to give custody to a person that this other parent has already said, I don't mind if this person has custody of the child. But if they're not willing to do that, they will, at least you can mail them a acceptance of service, have them sign it with the notary, and return to your office. That will be sufficient. That cures any service also. So there's several ways to do service. Again, I wouldn't worry too much with it, because once you get into it, you'll see that either they know how to get a hold of the person, they at least have an address so that you can do an order of publication, and so there are absolutely options that are available to you. Any questions from Charleston, Tammy?
Not that I'm seeing.
Anything else you want to add? Great. Well, thank you very much. Like I said, if you have any questions, I'll stick around for a while, and if any come in, I'll be happy to address those. And thanks again, and good luck. Again, like I said, these are things that are really deposits in good karma bank, because this is really changing a disadvantaged child's life. Thank you.